Slip and fall statute of limitations. Slip and fall accidents can occur in an instant, resulting in serious injuries and unexpected financial challenges. Understanding the statute of limitations for filing a slip and fall lawsuit in New York is essential for anyone seeking justice and compensation. This statute sets a strict deadline for initiating legal action. If you miss this deadline, your case can be dismissed regardless of its merits. If you or a loved one has been injured in a slip and fall accident, it's important to act swiftly and seek professional legal advice. At Kucher Law Group, our experienced Brooklyn slip and fall attorneys are here to provide the guidance you need to ensure your case is filed within the legal timeframe. Contact us today at 929-563-6780 for a free consultation and take the first step toward securing your rights and recovery. Understanding statute of limitations for slip and fall lawsuits. The 3-year statute of limitations. Under New York Civil Practice Laws and Rules Section 214, the statute of limitations for filing a slip and fall lawsuit against a private defendant is 3 years from the date of the incident. This means that if you are injured in a slip and fall accident, you must file your lawsuit against the property owner within 3 years of the accident date. This same 3-year deadline applies if you are seeking compensation for property damage resulting from the fall. The 1 year and 90 days statute of limitations. In New York, for claims against municipal corporations, like the City of New York City Housing Authority, local towns, and counties, the statute of limitations for filing a slip and fall lawsuit is 1 year and 90 days from the date of the incident. Additionally, you have 90 days from the date of the accident to file a notice of claim with the municipal corporation. Importance of timely filing. Timely filing of a lawsuit is essential not just for meeting legal requirements but also for strategic reasons. Even if you anticipate that your injury claim will be settled out of court, having the option to file a lawsuit provides significant leverage during settlement negotiations. It signals to the opposing party that you are prepared to take your case to court if a fair settlement cannot be reached, potentially encouraging a more favorable settlement offer. Factors influencing slip and fall statute of limitations. Discovery of injury. The discovery rule can influence the statute of limitations by allowing the clock to start ticking from the date the injury was discovered or reasonably should have been discovered. Defendant's identity. If the slip and fall occurred on government property, different rules apply. For instance, claims against a municipality or government entity typically require a notice of claim to be filed within 90 days of the incident, and the lawsuit itself must be filed within 1 year and 90 days. Legal disabilities. Certain legal disabilities, such as mental incapacitation or being a minor, can toll or pause the statute of limitations. For instance, if the victim is a minor, the statute of limitations does not begin until they turn 18, giving them until their 21st birthday to file a lawsuit. Similarly, if the victim is mentally incapacitated at the time of the accident, the statute of limitations may be tolled until they regain mental competency. Fraud or concealment. If the property owner or responsible party fraudulently conceals the cause of the slip and fall, the statute of limitations may be tolled until the fraud is discovered. Initiating a slip and fall claim in New York. Notifying the property owner or occupier. 1. Documenting the incident. It creates an official record of the accident, which can be crucial for your claim. 2. Prompt action. It allows the property owner to address hazardous conditions, potentially preventing future accidents. 3. Legal compliance. In some cases, especially if the property is owned by a government entity, specific notification requirements must be met to preserve your right to file a lawsuit. Be sure to provide detailed information about the accident, including the date, time, location, and circumstances that led to the fall. Gathering evidence for a slip and fall lawsuit. The more concrete and compelling your evidence, the stronger your case will be. Key types of evidence include: 1. Photographs and videos. Capture images of the accident scene, focusing on hazards like wet floors, uneven surfaces, or poor lighting that contributed to your fall. 2. Accident report. If the accident occurred in a public place, ask for an official accident report to be filed, and obtain a copy for your records. 3. Medical records. Seek immediate medical attention and keep detailed records of your diagnosis, treatment, and medical expenses. Retaining documentation of the incident. This documentation should include medical bills and records, which demonstrate the extent of your injuries and related expenses. Additionally, it is essential to keep copies of all correspondence with the property owner, insurance companies, and legal representatives. Recording any out-of-pocket expenses related to your injury, such as transportation costs for medical appointments or home care services, in an expense log is also necessary. Identifying witnesses to the slip and fall accident. Start by gathering the contact information of anyone who saw the accident happen, including their names, phone numbers, and addresses. It is also important to stay in touch with witnesses to ensure they are available if needed for further statements or court appearances. Proving liability in New York slip and fall cases. Evaluating the severity of slip and fall injuries. The severity of your injuries plays a significant role in proving liability and determining the compensation you may receive. Medical documentation is essential to illustrate the extent of your injuries, the treatments required, and the impact on your daily life. Establishing negligence in slip and fall cases. 1. Duty of care. Show that the property owner or occupier had a legal duty to ensure the premises were safe for visitors. 2. Breach of duty. Provide evidence that the property owner or occupier breached this duty by not addressing or warning about the hazardous condition. 3. Causation. Prove that this breach directly caused your slip and fall accident and resulting injuries. 4. Damages. Demonstrate the actual damages incurred, such as medical expenses, lost wages, and pain and suffering. Comparative negligence in New York slip and fall claims. New York follows the principle of comparative negligence, which can affect the amount of compensation you receive. Under this rule, your compensation can be reduced by the percentage of fault attributed to you for the accident. Calculating damages in slip and fall lawsuits. Economic damages in slip and fall cases. Economic damages refer to the quantifiable financial losses that a victim incurs due to the slip and fall accident. 1. Medical expenses. 2. Lost wages. 3. Property damage. Accurate documentation, such as medical bills, pay stubs, and repair receipts, is crucial for substantiating these economic damages. Non-economic damages in slip and fall claims. Non-economic damages are more subjective and cover the intangible impacts of the accident. 1. Pain and suffering. 2. Emotional distress. 3. Loss of enjoyment of life. Calculating non-economic damages often involves considering the severity and permanency of the injury, the victim's age, and the overall impact on their quality of life. Punitive damages in extreme slip and fall cases. Punitive damages are not commonly awarded in slip and fall cases. They are reserved for situations where the defendant's conduct was particularly reckless, malicious, or egregious. The purpose of punitive damages is to punish the wrongdoer and deter similar behavior in the future. To be awarded punitive damages, the plaintiff must provide clear and convincing evidence that the defendant's actions went beyond negligence and involved willful misconduct or gross negligence. For example, punitive damages might be considered in cases where a property owner repeatedly ignored known hazards despite prior accidents or warnings. Protect your rights with the legal help of an experienced Brooklyn slip and fall lawyer. Understanding the statute of limitations for slip and fall cases in New York is essential for protecting your legal rights and ensuring that you have the opportunity to seek compensation for your injuries. Filing your lawsuit within the designated timeframe is crucial, as missing the deadline can prevent you from obtaining the justice and financial recovery you deserve. If you've been injured in a slip and fall accident, don't wait to take action. Consulting with an experienced Brooklyn slip and fall attorney can make all the difference in navigating the complexities of your case and maximizing your chances of a successful outcome. Contact Kucher Law Group today at 929-563-6780 for a free consultation, and let us help you move forward with confidence.